And so we're going to bring in criminal defense attorney Ian Friedman. He's an attorney in Cleveland, Ohio. I want to thank you very much for being with us today. Ian, thank you very much.
Thanks, Michael. It's great to see you. Great to see you.
All right. So I want to chop this up a little bit with you because, as I said, one of the most fundamental things in our criminal defense system is that defendants are supposed to participate in their defense. You often see it if they are incapacitated in some way and cannot help. That is often used to slow down the trial process. So I want to ask you, in this instance, I was certainly surprised by the tactic taken by the criminal defense here in this case. How do you think about going forward in a case? What do you think about going forward in a case like this and conceding that it was indeed homicide rather than an accident, as your defendant was already on the record as saying?
Yeah, so there was a lot going on around that point. Number one, if it was in fact to the surprise of Mr. Mullis, you can imagine what that did to everyone else in the room. Now, by conceding that, you've said, well, it's either Mr. Mullis or it's the 13-year-old boy who found the mom. Jury's going to have a really hard time with that unless you have something really pointing the finger at the child. So it's a tough way to go. I think that there's a greater lesson here right from the start for younger lawyers and anyone involved in the criminal justice process. And that is, if the lawyer is going to make a bold tactical decision like that, put it in writing up front. Make sure that later on, if there's any claim by the client that, hey, I didn't know, that's why we paper the files. So this could have easily been avoided. But Michael, you bring up a great point. The defendant has a right to participate in the case, but really, what does that word mean, participate? And it's to actively participate. It's to be a part of that defense. It's to understand what all of the decisions are, and it's to authorize that, because perhaps the lawyer and the client don't see eye to eye at some point, and maybe at that point they have to visit whether or not continued representation is in the best interest of the client. So there's a lot that goes into it. Communication is key. It cannot be overstated. And again, as the lawyer, and something so as important as this, I would have made sure that I had something in writing with Mr. Mullis' signature saying, I do in fact acknowledge this. And without it, now this is going to be a problem that's going to go on for years. An appeal and post-conviction with the two people arguing, one person's word against another.
Yeah, that's a great point, getting it in writing, because, I got my upbringing in the criminal defense world, and, you come across defendants who just have really some crazy ideas. And oftentimes it comes down to a sort of a fight with them. And I don't use that word lightly, you're fighting with your defendant about how and you want to try the case. Now, have you ever come across instances where you want to go in one direction, defendant wants to go in a different direction? How do you sort of reconcile those two things?
Sure. So again, it really comes down to the pretrial preparation. If that issue comes up either during or even just before trial, you're in trouble, because sometimes these issues, when we're dealing with life and death, it takes a long time to resolve these issues. You cannot always assume that your client's wrong, right? We may believe that with all of our experience, we have the right answer, but sometimes they'll bring up a good point. So you want all the time that's necessary to really go through all of these issues, vet out all of these issues. And if you disagree with your client, make sure that you have fully examined it so that you can sit down and say, Mr. Client, I hear you. Here's the reasons why I disagree with you. Here's the better strategy that I think. Let them know that they're being heard, but then also remind them that this is the world that we live in, and here's why we don't believe it's going to resonate well with either the jury or the judge. Michael, as you know, regardless of what side of the aisle we're on in the criminal justice system, whether we're with the prosecutors dealing with witnesses and victims, or whether we are on the defense dealing with defendants, the issue is always going to be communication. And that's, absolutely what the problem's going to happen here. Mr. Mullis said he had never heard this until it was said in court. If true, absolutely going to be a problem. At the very least, though, now this has got to be heard on appeal for the longest, and no one's going to be able to be settled with this verdict for years while it's going through the appellate process.
Yeah, hard to believe his prior attorneys had between the two of them, over 50 years of experience. Hard to believe they wouldn't have told him which direction they were going. But I will say this, with all that experience, one thing I know, if you're going to concede the fact that this was indeed a murder, you got to come up with what I used to call a boogeyman. You got to come up with an alternate theory. You got to give the jury something to put their hat on. If you're going to say it was a murder, but my guy didn't do it, you got to give him somebody else who probably did, and then some sense that he did in fact do it, had the motive, had the means, or something. Don't you agree?
Absolutely. Otherwise, if you say, here's all the evidence, but we think that it was someone else who did it, you got to have something. I get that we don't have any burden, right, as in the defense camp. But if you're going to try and project it elsewhere, you are absolutely right. You've got to have something. Otherwise, the jury is going to say, typical defense stuff, smoke and mirrors. But here, as you said at the onset of this show, it really can be rather simple if the jury, so chose it, because 4 prongs, 6 holes. This really comes down to kind of a forensic recreation of the pathology and so forth. They had to, come up with something, some other plausible mechanism for this injury, whether it was murder by someone else, and here, again, difficult. You're trying to put it on the 13-year-old boy, or an accident, and there's got to be, did she fall on it and last second push up and fall back down? I mean, you have to have something. So in answer to your question, you are spot on.
Yeah, I agree with you 100%. Okay, so we're going to take a quick break here. Ian, stand by. Folks, please stand by. When we come back, we're going to take a look at another issue that was in front of the judge, and that is that 911 call and prosecutorial misconduct surrounding it. So stick around here on Court TV Live.
Now, Todd, here I'm gonna play you the part where you're doing the chest compressions, and I'm just gonna ask that you listen in between the chest compressions, okay? Todd, do you whisper cheating whore right there?
No.
Okay, I'm gonna play another clip for you. Right there, do you say go to hell, cheating whore?
No.
So you don't hear that?
No.
You holding the phone and doing the compressions at the same time.
Yes.
You knew you were on a recorded line with a 911 operator.
Yes.
Do you believe that you said, whispered, cheating whore or go to hell, cheating whore while you were doing CPR?
No.
And I know today you heard some evidence about those whispers on that 911 call. And I'm going to implore you to listen to that 911 call. You can hear the defendant whisper, cheating whore. And if you go at 7.00, you can hear, go to hell, cheating whore.
Well, that was Prosecutor Maureen Hughes talking about a 911 call. And what was interesting, this was one of the more dramatic parts of this trial. She claims that she heard him say cheating whore or die cheating whore or something to that effect on the tape of the 911 call when he found his wife and called 911 to get help. There was never really a consensus on whether he actually said it or not. But again, once you mention it, it's almost something that sticks in your head, and then you begin to hear it and you're like, well, maybe I do hear it. But without that suggestion, not exactly sure. So let me bring in criminal defense attorney Ian Friedman. Now, Ian, this was one of the areas in the trial that I had a little bit of a problem with. I felt this was, I don't know, there was something about this that struck me wrong. I'd love to get your opinion on what Maureen Hughes did at this point with this information on that 911 call. Is this something you would have objected to strenuously, or how would you have dealt with this?
Obviously, as defense counsel, I would not have liked it. And one of the things that stood out to me was looking at the faces of the 2 defense lawyers as the prosecutor made the suggestion as to what Mr. Mullis said. And you could see on one of their faces just complete surprise and almost, disgust and whatever. It clearly caught him off guard. So would I have liked it as defense counsel? No. But here's the but. The but is this is evidence that had been admitted. Both parties had the opportunity to examine it. listen to it as much as they wanted. They could have had it forensically analyzed. And so it was admissible. Now, the prosecutor in closing argument, and as the judge stated, and no one objected to the instructions, argument is not evidence. And what she is doing is, as much as I, again, would not like it, the law is what the law is. And she's telling the jury what she believes the evidence showed. And in this case, the evidence included that 911 call. It was her belief that that's what was said. And so now that just goes to the determination of the jury. Now, I think that the defense lawyers, at least by their faces, seem to be caught by surprise, probably couldn't respond to it as well as they would have wanted. Absolutely probably terrified when they walked out of the court. I've had that happen maybe before too, where the other side kind of made their interpretation of the evidence. It was certainly different from what I heard, but that doesn't get it excluded. That just gets it to the jury to do what a jury does, which is determine what they feel was said.
All right. Now, according to the brief filed by the defense here, I want to read from it. It says, further, the court specifically identified examples of prosecutorial misconduct, and they name a couple of different things, and they get to a point where they say, making unsupported statements during closing argument. Now, I want to move along to the closing argument. Once she mentioned it during the testimony when Todd Mullis was on the stand, she then again mentions it in her closing argument. How does that play in your mind in terms of, at that point, should it then be off the table, or is she perfectly within her right to do it there?
No, I think she's perfectly within her right. And I mean, really, she gave Mr. Mullis the opportunity to respond to it. She asked him twice, did you say that? She played it back. He said no, expectantly, but she still believed, and in the motions hearing just prior to sentencing, she even said, look, it's my belief that that's what he said. Whether or not the jury went along with that, we won't know, because their determinations stay with them. But she is within her right to say, this is what I believe. I mean, he didn't have to agree with it. I mean, I would not expect for him to say, yes, that's what I said. And she did tell them, you go back, you listen to it. Here's the time frame. I believe she said 7 minutes, and you'll hear it. That was her belief. So, but again, at the end of the day, was that a central issue? I don't know. And the appeals courts are going to look at that. They're going to look to see, number one, was it error? Number two, even if it was, would it have changed the outcome of the verdict? And I think it's still going to come back to, kind of the big issue in the room that you and I have already discussed here, which is the mechanism of injury and any alternate, plausible explanation for that.
Quickly, let me call up a board here. Now, one of the things that the judge has to consider when they're considering something like this, a claim of this nature, they have to come up with something they call Graves test. Now, the Iowa Supreme Court ruled that if, in fact, they find that there's misconduct, it's not enough. Once you find misconduct, then it has to meet certain criteria in order for it to have deprived the defendant of his right to a fair trial. And the first thing there is the severity and pervasiveness of the misconduct, the significance to the central issue, the strength of the state's evidence. And then there's a couple of others that don't really apply to this case, the use of the cautionary instructions, which they weren't given in this case, and the extent to which the defendant invited the misconduct. Again, that was not applicable here. So I want to talk about the first one, the severity and pervasiveness of the misconduct. It was used in cross, it was used in the closing, and we talked a little bit about that. But the next one, and you just mentioned it, was regarding the strength of the state's evidence. Now, I sort of disagree with you. I think one of the central issues in this case was motive. You had to provide a motive. And their motive that they were trying to say Todd Mullis had was that he was jealous and angry at his wife, didn't want to lose his farm because this woman was cheating on him and making his life very difficult. And if they got a divorce, she was going to take half of everything he worked so hard to build. Now, I thought this was central to getting the jury to believe that point. What say you?
No, I agree with you that it is important because of the motive. However, the mode in which she did it, I think, still keeps her in bounds. She gave the opportunity to address it. He denied it. It then went to the jury, and she told them to make up their minds. Of course, she wants them to believe it because it goes along with the motive of the case. So is it important? Yes, you and I agree with that. But did she run afoul of how to do it? No. So I'm looking more at a procedural issue, but I think the effect of it, the prejudicial effect of it, could be and should be deemed that which would warrant some sort of sanction if she did it in a way that violated procedure. I just don't think she necessarily violated the procedure in the way that she brought it to the jury. Now, if the court disagrees with that, and I don't see the rule in which they do, but for whatever reason, we always, we never know what a court's going to do. Then they could look at it and say, did this rise to a level that was so severe that he was deprived of his rights to a fair trial? Well, yes, the appeals lawyer is going to tie that in to the underlying theme that the prosecutors brought from start to finish. And even right until the very end of the case, you heard the prosecutor say, Your Honor, under the Victims Restitution Fund, $150,000 isn't enough. This whole case was about greed and jealousy and so forth. So you're right, Michael. That's the whole case. But they still have to show an initial violation. And I don't see a court of appeals reversing on that issue.
Yeah, strong moment there in that hearing. Ian Friedman, stick around. We're going to take a quick break. And when we get back, we're going to take you back live to Manchester. Stay with us.